Committee on State Affairs will come to order. Will the clerk call the roll?
Betancourt, Birdwell, Hall,
Here.
Hinojosa, Middleton, Parker, Perry, Shortner, Zaffarini, Paxton, Hughes.
Here. Welcome, everyone. We'll begin with our posted agenda, and the chair lays out Senate Bill 1065 by Senator Hall, and recognizes our colleague, its author, to explain the measure. Good morning, Senator.
Thank you, Mr. Chairman and members. Back in 2015, Texas lawmakers passed House Bill 910, which let licensed Texas carry handguns openly in places where it's not prohibited. That same year, Governor Abbott signed Senate Bill 11, the Campus Carry Bill, allowing licensed individuals to carry concealed handguns on university campuses. Then in 2021, the legislature passed House Bill 1927, removing the requirement for a license to carry in most public places, introducing what has been known as constitutional carry. Through these laws, the legislature has made its intent very clear. We're to protect and uphold every Texan's right to self-defense. In 2024, the State Fair of Texas denied citizens their right to self-defense, implementing a no-gun policy prohibiting firearms on its fairgrounds by license holders. This decision, made in response to a prior shooting incident involving a gun illegally smuggled into the grounds by a non-license holder. This initiated legal challenges and debate over whether a private entity operating on public land has the authority to override state laws protecting licensed guns rights. Unfortunately, the liberal anti-gun lobby convinced the court to side with them. This situation highlights the broader issue of conflicting state firearm policies enforced by private entities on government property, as well as the inconsistent enforcement of Texas law. Texas law protects the rights of licensed gun holders to carry firearms in most public places, yet contractors using property owned or leased to them by government entities have recently imposed unauthorized restrictions on these rights. This creates confusions and inconsistencies in the law, with licensed handgun holders being unfairly prohibited from accessing public spaces where state law otherwise allow them to carry firearms. These restrictions undermine the intent of Texas law, Second Amendment rights, and creates unnecessary barriers for responsible licensed gun holders from their right to self-defense. This bill simply requires that the contracts for the use of property owned or leased by government entities include provisions prohibiting contractors from renting or leasing government property, with restricting licensed handgun holders from carrying firearms unless otherwise prohibited by state law or Section 46.03 of the Penal Code. It will impose civil penalties ranging from $1,000 to $10,005 per violation on contractors who unlawfully restrict handgun holders from entering or remaining on the property, and allow licensed handgun holders to file complaints against contractors violating these provisions, requiring written notice to the contractor and a 3-day window to cure the violation. Authorize the Attorney General to investigate complaints, issue penalties, and seek legal relief, with penalties deposited into the Compensation of Victims Crime Fund. Require that contractors that are renewed, modified, or extended after the law's effective date comply with these requirements, applying the provisions prospectively. Mr. Chairman and members, this bill is about restoring consistency, clarity, and respect for the rights of law-abiding Texans to defend themselves. When individuals receive a license to carry from the state of Texas, they do so under trust that their rights will be recognized and upheld according to state law. That trust is undermined when private entities operating on a public land impose restrictions that exceed their legal authority and directly contradict the laws of this state. This bill ensures that government property cannot be used as a backdoor to deny Texans their lawful right to carry, and it provides reasonable enforcement mechanisms protects the public safety, and ensures that our laws are applied fairly and consistently regardless of who is managing the property. I respectfully ask for your support in moving this important legislation forward and joining me in supporting and protecting the rights of Texans to defend themselves. With that, Mr. Chairman, I have to take any questions.
Thanks, Senator Hall. Members, any questions for Senator Hall on Senate Bill 1065? All right, we'll open testimony, and we'll begin with invited witnesses. The chair calls Gary Zimmerman, John Poole, Nicholas Tuccio. Welcome to each of you. If you have a preference for the order to go in, you're welcome to do that. Otherwise, we'll start on my left over here. And if y'all don't have a preference, we'll have you can go first, or introduce yourself and give us your testimony. Welcome.
Good morning, Chairman Hughes and distinguished members of the Senate State Affairs Committee. I'm John Poole. I'm the Executive Director of the Texas State Rifle Association. I'm here today to testify in favor of Senate Bill 1065. I've been a member of Texas State Rifle Association since 1988. I'm also a retired law enforcement officer for 26 years in the U.S. Border Patrol, and I was a Marine before that. My whole life has been dealing with firearms. I got my first hunting license and my first gun at the age 10. I was on the national shooting team for 23 years and put approximately 3 million rounds downrange in my career between military, law enforcement, and competition. As I speak today, it's from a position of experience. As you know and read, Senate Bill 1065 is designed to close a loophole and allow license to carry permit holders to continue to protect themselves and others. In reading, the city of Dallas ran the state fair at Fair Park. Current state law prohibits them from adopting and enforcing gun bans there. But because of the exact same taxpayer-owned property is leased by the city to a nonprofit organization, our Second Amendment rights can be nullified. That is a loophole that needs to be closed, and Senate Bill 1065 will do that. In August, there was already previous support. A letter was sent and signed by 70 Texas state lawmakers to the state fair to urge them to rescind their policy, and those 70 representatives represented millions of Texans. We here at the Texas State Rifle Association during the latter stages of 2024, from August to December, the TSRA we just sent out 9 email alerts related to the gun ban at the state fair, which would ban legal license to carry permit holders from entry and protecting themselves while attending the state fair. Over that period of time, our emails were engaged by 30,000 members. And as for our social media posts, those reached over 121,000 members. Not just members, but also Texans. Currently, there is 1.5 million active license to carry holders in the state of Texas at this time, and that is counting in number as per the Department of Public Safety. Prior to the policy change, the fairgrounds allowed LTC holders to carry at the fair. Of course, as we already spoke of in 2023, one attendee with a firearm who was not supposed to have it created a shooting and an incident. This the knee-jerk reaction by the state fair was a policy change that not only banned all weapons, but it banned the very people that you want to carry a handgun. The ones who've had the background check, who've had the safety courses, passed the shooting qualifications. This policy change really only bans the people that follow the law. The passing of this bill will help fix the problem, protect law-abiding Texans, continue to be a protection force multiplier for themselves and others. In closing, sir, I would like to thank Senator Hall for filing this important piece of legislation that the Texas State Rifle Association favors.
Thank you for your testimony. We'll have questions for the whole panel after we hear from each one of you. Thank you. Go ahead, introduce yourself and give us your testimony.
Chairman Hughes, members of the committee, thank you for the opportunity to offer testimony on Senate Bill 1065. My name is Nick Tuccio, and I am representing the National Rifle Association as their state director. The NRA is here today to voice its strong support for Senate Bill 1065, a critical piece of legislation that directly safeguards the Second Amendment rights of law-abiding handgun license holders in the state of Texas. The right to keep and bear arms is a fundamental right, and Senate Bill 1065 takes an important step to ensure that this right is respected across our state, even on government-owned or leased property managed by contractors. In our estimation, Senate Bill 1065 is a vital piece of legislation that would strengthen and uphold the Second Amendment rights of law-abiding citizens. For example, if we're referencing stats, even in the instances of whenever citizenry versus police officers, licensed to carry holders commit felonies and misdemeanors at 1/6 the rate of police officers as observed in Texas and Florida. These are a fundamentally law-abiding population that the restriction of this right in this matter is a serious concern. By ensuring that contractors operating on government property respect the right to carry for licensed individuals, consistent with the laws already applied to government entities themselves, Senate Bill 1065 will prevent further infringements like the one we are currently witnessing at the Fair Park. The NRA strongly urges your support for the swift passage of this important bill. Thank you.
And thank you for your testimony. Welcome. Introduce yourself, and since you're on the end, you got to get close to the microphone and give us your testimony.
My name is Gary Zimmerman. I'm here representing myself. I am a licensed to carry instructor for 4 states, Texas, Illinois, Maryland, and Utah, as well as I have 10 licensed to carries from 9 other states besides Texas. I can attest to you that as a licensed to carry instructor, those of us in Texas with a license to carry instructor are the most law-abiding citizens in the state of Texas, more law-abiding than even law enforcement officers themselves. A friend of mine's brother went to this last Texas State Fair this year. He spent the day enjoying the state fair with his family, his wife and his 2 daughters. They parked down near where the Texas State Fair is. The Texas State Fair is in a high crime rate area of Dallas. When they got back to their car, they were met by 2 gentlemen, one with a gun, and they were robbed. Their cell phones were taken, and their guns that they had to keep in their car were also stolen. If he had been able to carry, this might not have happened. The problem isn't with safety at the state fair, it's getting to and from the state fair. Because we have to go from our homes and either take the DART train or drive. We have to park down there. And the problem isn't the state fair because there's 500 plus police officers there. It's getting to and from there, and the state fair of Texas is in the highest crime rate area of Dallas. So it's not even safe to go there. Where are you going to put your gun? In the car. Where's the #1 place that criminals obtain guns? It's from stealing them from cars. It's not from buying them. They steal them from cars. And if they know everybody going into the state fair or coming out isn't going to be carrying, and it's going to be in their cars. So they rob the cars, or they meet the people as they come out of state fair to rob them at their cars. We need to pass this bill so that we can allow ourselves to carry again. It's public property. It's our Second Amendment right. We need to pass this bill and tell the state fair, as well as anyone else contracting with public property, we have the right. Thank you.
Thank you for your testimony. Senator Hall, you have the panel.
I think Mr. Poole, you made a comment about the incident that caused this. And as I understand it from the reporting, it was an illegal gun that was retrieved through a hole in the fence by someone who is not licensed to carry, and an incident followed from that.
Correct, sir.
Is that correct? Okay.
Yes, sir, very much so.
What the park did, or the contractor did nothing to fix that. I believe it was reported that even when the fair reopened the next time, the hole in the fence still existed. They had not even closed it up.
It did.
And so their knee-jerk reaction to think they're going to solve their problem by keeping the law-abiding citizens out was kind of misplaced.
Very much so, sir. Again, they're taking away the ability for somebody to protect themselves, their families, or innocent others that could be there. Again, in the shooting, there was 3 people that were shot. Two of them were bystanders. And there was nobody there to protect them. They were innocent parties that were injured because somebody else wasn't there that would have the ability to have protected them.
Okay. And in recognizing what this bill could do and the limitations we have with the contract that currently exists and exists through 2038, I believe, the way it works out.
Yes, sir.
Some people like to talk about the shortcomings of their bill, but this one definitely has one in it, is that this will not become effective unless they modify or amend the contract sometime between now and then.
Yes, sir.
But there is a solution, and that would be the 30-06 sign. I believe the bill we have 82, that if you put up a 30-06 sign, then you assume responsibility. Like in your case of someone who had to leave their gun in their car because they went into the facility and then they were assaulted. It was physical assault of them in taking their property.
That is
And
correct.
so kind of like, this is a little bit more than belts and suspenders, but these two bills kind of go together. Would you agree with that?
I agree. But this bill would also affect every other place in Texas that leases to contractors, like in Houston or Amarillo or anywhere else. So we need this bill to protect not just the state fair, but everywhere else in the state that happens to have a contractor that leases public property to have an event.
Absolutely. It's not limited to just the fairground. The fairgrounds were what initiated the recognition to need to do this.
Yes, sir.
It would have statewide effect, which
Yes,
is
sir.
the really good side of it. Thank you.
Thank you, Senator Hall. Senators, any other questions for our witness? Senator Parker, you're recognized.
Thank you, Chairman. I just want to thank you guys for your testimony and all you do for Texas and protecting gun rights. So appreciate you being here. Thank you.
Thank you.
Thank you, sir.
And we thank each of you for being here. Thank you very much for your testimony. We'll open public testimony on Senate Bill 1065, and the chair calls Sarah West, Chris McNutt. Ms. West and Mr. McNutt are the only witnesses who have registered to testify. So if anyone else wishes to testify on, for, or against Senate Bill 1065, please make your way down and identify yourself so we can hear from you. All right, Ms. West, welcome. Introduce yourself and give us your testimony.
Thank you. Thank you for the opportunity to speak this morning in opposition to SB 1065. My name is Sarah West, and I am speaking on behalf of Moms Demand Action and Everytown for Gun Safety and myself. We are firmly opposed to the proposed policy that prohibits contractors, such as the State Fair of Texas, from restricting licensed handgun holders from carrying firearms on public land. When the state or a city brings in a contractor to hold a large event, we entrust them with serious responsibilities, including following federal and state laws and protecting their workers and the public. If we forbid them from restricting firearms, we are undermining their ability to keep these events safe. After experiencing a shooting at the State Fair in 2023, the State Fair stated, "Safety is the #1 priority of the State Fair of Texas. We are committed to upholding the level of security required to ensure the State Fair of Texas event is a safe and family-friendly environment for all fairgoers, vendors, and employees." Logically, a state fair that experienced a shooting in 2023 would try harder to limit the possibility of it happening again in 2024. SB 1065 imposes a one-size-fits-all gun mandate on settings as varied as public streets, the Houston Zoo, and public universities. It strips event organizers of the flexibility they need to make site-specific safety decisions and potentially opens the door to liability exposure or high insurance premiums. The organizations holding these large publicly accessible events are blamed when something goes wrong. A shooting victim is suing one of the security companies from the 2023 State Fair. We cannot demand accountability from contractors while denying them the authority to set reasonable safety rules. I urge this committee to reconsider this policy.
Thank you for your testimony. Ms. McNutt, welcome. Introduce yourself. Give us your testimony.
Yes, my name is Chris McNutt, and I'm the president of Texas Gun Rights, speaking in support of Senate Bill 1065. I want to thank Senator Hall for filing this important legislation. I think it complements your SB 82 and several other bills very well that are part of our overarching priority to eliminate dangerous gun-free zones. Of course, last fall, we joined along in the efforts to try to strike back at the state fair's actions, working with Speaker Burrows at the time, and then our legal brief filed by our legal counsel, C.J. Grisham, actually influenced some of the lawsuit filed by A.G. Paxton. So just want to thank you for taking the torch to have a legislative solution while this still continues to play out in the courts. But this bill is extremely important because more than 98% of mass shootings that have ever taken place since we started tracking them in 1950 have occurred in dangerous gun-free zones. These are areas where law-abiding citizens are stripped of their right to protect themselves. And oftentimes, when every second counts, the police are always minutes away. And not only that, the number one place where firearms are stolen from are from vehicles. And according to Everytown's own statistics in 2022, more than 50% of stolen firearms originate in vehicles. So this policy is directly promoting, by the state fair, is directly promoting stolen firearms ending up in the hands of bad people. So we just believe that this is a common sense law that is needed, and really it just brings back the intent of what the intent of the current state law should be. And thank you for your time.
And thank you for your testimony. Senator Hall, you're recognized.
I believe you said that the contractor has a responsibility for the safety of the folks that visit the fair.
Yes, that is part of.
Would you also agree that they failed in their job by allowing a unlicensed person to smuggle a gun through a hole in the fence, or however it mattered, into there and use it?
I'm not here
Did they fail?
I'm not here to litigate what happened on that day, but I can tell you that the shooting victim is suing the security company because the metal detectors were not 100% in.
Well, all the
keeping
reports were he
everybody's-
didn't come through a metal detector. But my point is, you said they have the responsibility, and they failed in their responsibility.
Yes, and so
it's
they
not
are
a solution.
trying to make rules and policies so that next time things won't fail. I'd also like to point out that, yes, while there are many guns stolen out of vehicles in this country every day, if we had safe storage laws which prohibited guns from being unsecured in vehicles, that would not be as much of an issue. Okay. So I wanted to point that out.
Okay. Thank you.
And thank you, Senator Hall. Senators, any other questions for Ms. West or Mr. McKnight? And thank you both for being here. You're excused.
Thank you for listening.
Is there anyone else wishing to testify on, for, or against Senate Bill 1065? Seeing and hearing none, public testimony is closed. Bill's left pending at this time.
No, your choice.
The chair now lays out Senate Bill 2742, and recognizes its author, Senator Hagenbu, to explain the measure. Welcome, Senator.
Good morning, Mr. Chair and members. Appreciate you giving me the opportunity to do this today. Today, I'm here to lay out SB 2742, which addresses electioneering by independent school districts, ISDs. In the lead up to the 2024 general election, the Office of Attorney General was made aware of multiple cases of electioneering by ISDs across the state. Presently, under current state law, Texas school officials may not use public resources for political advocacy, but there is no penalty for such violations. The Office of the Attorney General only means of recourse is to stop this behavior is to seek injunction relief in court. But this option only serves as a temporary fix to stop the behavior. There exists no means in current statute to permanently stop or dissuade the behavior, and it's not the intent of the current statute to allow ISDs to operate under sovereign immunity or political subdivision. Senate Bill 2742 would create a means to deter ISDs from electioneering by establishing a civil penalty for this behavior. In addition to creating a civil penalty for the Board of Trustees of school districts who violate this act, the bill also creates a civil penalty for the responsible officer or employee of the school district. The bill waives and abolishes immunity for school districts and their officials and employees who violate this act and allows the OIG to bring suit to collect a penalty under the bill. School districts may not indemnify officers or employees who must pay a penalty. The Office of Attorney General may recover attorney's fees and court costs in suit brought under this bill. We did not have the committee substitute in time, but there is no change in the substitute. It simply changes the non-council version to a council draft. The SB 2742 strengthens existing laws prohibiting electioneering with public resources by creating meaningful civil penalties, waiving immunity defenses, and reinforcing the Attorney General's enforcement authority. It aims to uphold the integrity of the public institutions and ensure taxpayer resources are not misused for political purposes. Today we have Ernest Garcia, Chief Administrative Law Division from the Office of Attorney General, as a resource witness. Thank you, Mr. Chairman and members.
And thank you, Senator. Members, any questions for Senator Hagenbu on Senate Bill 2742? Very good, thank you. We'll open public testimony on Senate Bill 2742. And the chair calls Andrew Hendrickson. Mr. Hendrickson is the only witness who is registered to testify on, for, or against Senate Bill 2742. And I'll ask if there's anyone present wishing to testify on, for, or against Senate Bill 2742. Seeing and hearing none, public testimony is closed. And of course, we'll show Mr. Hendrickson's position against the bill. And the bill is left pending at this time. The chair lays out Senate Bill 2743 and recognizes its author, Senator Hagenbu, to explain the measure.
Thank you again, Mr. Chairman and members. I'm here today to lay out the committee substitute for SB 2743. This bill pertains to local prosecutors who refuse to prosecute election offenses. Currently, if a local prosecutor consistently refuses to prosecute an election offense without sufficient legal reasons, the citizens of the state of Texas are without recourse for justice. And SB 2743 would authorize a district court to disqualify local county and district attorneys who refuse to prosecute election offenses and appoint the Texas Attorney General to prosecute on behalf of the state. The committee substitute for SB 2743 makes the change to allow a judge of a court in an adjacent county upon petition for removal by a resident to disqualify an attorney who refuses to prosecute election offenses. Additionally, the changes require a judge to disqualify the attorney who refuses to prosecute election offenses and appoint the Attorney General to represent the state. Committee sub for SB 2743 establishes a legal safeguard to address non-enforcement of election laws by allowing limited intervention by the Attorney General. It seeks to balance the need for consistent statewide enforcement with the protection of local prosecutorial autonomy through a structured judicial review process. We are still communicating with the Office of Attorney General. It's possible there's still clarifying language we need to add, but we wanted to do the layout today so the committee could be introduced to the bill. We have today here with us Amber Platt, Associate Deputy Attorney General for Criminal Justice for the Office of Attorney General as a resource witness. Thank you, Mr. President and members.
Thank you, Senator. And you mentioned your committee substitute. We'll make sure that all the members have that to go over it. And so, thank you for explaining that to us as well. Members, any questions for the author our colleague on Senate Bill 2743? Very well. We'll open public testimony on Senate Bill 2743, and the chair calls Ed Johnson, Veronica Warms. There we go. I think they're both here. Welcome to each of you. Mr. Johnson, Ms. Warms are the only witnesses who have registered to testify on, for, or against Senate Bill 2743. If anyone else wishes to testify on, for, or against 2743, please come to the table now and identify yourself so we can hear from you.
Hi.
Welcome to each of you. Ms. Warms, looks like you're in the pole position. Welcome. Introduce yourself and go ahead.
Sure thing. My name is Veronica Warms, representing the Texas Civil Rights Project against SB 2743. This bill would allow any private person to challenge a local district attorney's ability to participate in an election offense case if they exercised any discretion or leniency to people charged with an election offense. It would then require the Attorney General to prosecute that offense. This attack on prosecutorial discretion is bad for democracy on multiple fronts. First, the DA, as an elected official, presumably executes the will of the voters with the types of cases they choose to prioritize with their limited resources. Second, prosecutorial discretion exists for a reason. It gives the DAs the flexibility to pursue cases that actually warrant being pursued because the evidence suggests that an offense actually occurred. But it also allows the prosecutor to make the decision that the evidence does not support the charge and decline to prosecute. That decision-making is vital to our democratic process. Otherwise, a private citizen could just challenge a DA's judgment that the evidence simply doesn't warrant wasting taxpayer money to pursue without any evidentiary support. Finally, the bill text is ambiguous and ripe for abuse. What would consistently refuses or declines to prosecute mean practically? Declining to prosecute more than once? When does a DA hit the threshold for removal? There's no way for a DA to know that, and therefore no way to curtail the bad actors who would likely come out of the woodwork to disqualify them. Nor is it clear what an adopted policy or practice means. What if the DA simply states to the office that they will not prosecute election offenses without actual evidence of an offense? Would that be a policy of declining to prosecute without count as disqualifying, since allegations with no evidentiary support are going to happen? This standard is vague and could be taken advantage of by bad actors. For all the reasons above, we ask you not to vote SB 2743 favorably. Thank you.
And thank you for your testimony, Ms. Warms. Ms. Johnson, welcome. Introduce yourself. Go ahead.
Ed Johnson. I'm Harris with the Harris County Ballot Security Department and a former Harris County employee under tax collector assessor Paul Betancourt, I tell you. So y'all are gonna hear some stories about Paul now. So back when I was director of voter registration, in the code, it required you to put together a list of everybody that voted that was not registered. And my boss made sure we made a very complete list, and we would have hundreds of people that we identified that were not registered to vote that ended up voting. And after every election, he would say, take it over to the county attorney in the DA's office. And I would pack all these boxes up with all their documents and all their records and walk over there, and I'd meet with the county attorney in the DA's office, and they would show me the closet that they stuck all those records in, and they never came out again, and never were prosecuted, never were even looked at. So all these cases where you had a clear voter fraud going on were never seen. Since then, being in the in Harris County under the ballot security, I can name numerous cases where we have collected evidence of voter fraud and presented it, and nothing ever happens to it. They just put it in that same closet over there. I can tell you where the closet is. So this would be a great tool to actually get some of these election fraud cases heard.
And thank you, Mr. Johnson. Senator Betancourt, do you have the panel?
Yes, a rejoinder story, okay? We did have one successful prosecution because an HISD secretary re-registered 173 people and moved them around because of some activity, election activity around an HISD elementary school. We identified her because she used, as Senator Zaffarine will remember, or Senator Hall, the big floriated Fs and S's, okay? Her signature was so distinct and large that it covered the entire registration card. And she signed several hundred of them, and that led her to a conviction. And then we had another problem that actually was, I call it a successful prosecution. It was in the Democratic primary where someone was attempting to re-register all the members of a church into one state representative district. Much like at the end of Animal House, that person's whereabouts were unknown. They attempted to find that person for several months into a few years. Never actually did find that person again. But I consider that to be a successful prosecution of voter fraud. So we spent more time doing voter fraud in the Democrat primary, quite frankly, than we did anywhere else.
You also had in the Democratic primary where the lady was registering illegals there, the college student that was signing the voter certificates for him, and you had a successful prosecution there?
So anyway, the bottom end of the story is that, yes, fraud does occur. So I happened to have been there and actually was one of the few voter registrars that actually had a conviction for fraud. But Ed, no more stories, okay?
Thank you, Sir Debate Court.
They're taking an alarmingly bad trend, okay? So let's go.
But it is serious because that was just the very tip of the iceberg that ever got prosecuted. I mean, I took hundreds and hundreds of cases over there, and they were never even looked at.
Senator, is there any other questions for Ms. Warren, Mr. Johnson? Thank you both for being here. You're excused. The chair calls Andrew Hendrickson. And while Mr. Hendrickson's coming, we'll ask if anyone else present wishes to testify on, for, or against Senate Bill 2743. Anyone else on, for, or against Senate Bill 2743? And we do have Mr. Hendrickson's position registered against the bill, which will, of course, be noted. And we will close public testimony on Senate Bill 2743. Bills left pending at this time. And so that the furniture can be rearranged for the Senate to come into session. With great thanks to our teams and all those helping us here, we will stand in recess up to the call of the chair, and we'll be returning upon adjournment or final recess today. Good morning.